So the first thing I want to talk to you about is the Prevention of Social Housing Fraud Act 2013. This was introduced to replace and streamline the previous system, and it was the result of coordinated national drive to clamp down on housing tenancy fraud, and in particular the unlawful subletting of social housing. In 2012, the Audit Commission, in its annual report, found that housing tenancy fraud was the largest category of fraud-related loss in local government, and that it affects an estimated 98,000 social housing homes in England. So it's a pretty big problem. Prior to the Act, and as I mentioned earlier, when a tenant did stop living in the property as their only principal home, if they moved back in before the notice to quit expired, they could regain their assured status. But that was in stark contrast to the situation for secure tenants who, if they stopped living in the property as their only principal home and lost their status as a secure tenant, they couldn't regain it by moving back in. So one of the most helpful things that the Act introduced was to align those two positions so that they were the same. And the Act introduced Section 15A to the Housing Act 1988 to assured tenants so that they would be in the same position as secure tenants, in that if they gave up the property, stopped living in it as their only principal home, they would lose their assured tenancy status and they would not be able to get it back, which would be very important when it comes to serving notices to quit. And I would say that this is the most helpful thing that the Act introduced, really. But you must comply with Section 5 of the Protection from Eviction Act. And what that means is that you've got to make sure that the notice to quit is in writing. It cannot be verbal. Lots of times I do get inquiries from people to say, well, the tenant gave notice to quit. And when I said, well, how did they do that? And they said, oh, they did it over the telephone. A notice to quit cannot be verbal. It has to be in writing. It has to give not less than 4 weeks notice. And it also has to contain information that is prescribed. So even though there's not a specific form that can be used, like I mentioned, the notice of seeking possession, that's form 3, court form 3, there's no court form for a notice to quit. It just has to be in writing, but it does have to contain information that can be found in the notices to quit prescribed information regulations.